The franchise agreement is at the core of the franchise system and franchise relationship. The franchise agreement or contract is the legal document which includes the entire arrangement made between the franchisor and the franchisee. Agreements can vary hugely in length from 10 pages or less to more than 50 pages. A franchise agreement describes the rights and obligations of the parties and sets out the basis for the relationship. Franchise agreements also include controls with the objective of protecting the integrity of the franchise system and the entire franchise network. Common key franchise agreement elements. Each franchise system is unique in some way, and two seemingly identical franchise opportunities might have quite different franchise agreement elements. However, there are common elements or topics covered that you will find in most franchise agreements. But again, it is important to note that individual elements, while common in concept, can contain subtle yet important differences. Please note, when undertaking your due diligence, there is simply no substitute for seeking legal advice from a lawyer experienced in franchising. They will be able to help you put your opportunity into perspective. We will now run through 12 common elements along with a brief explanation and considerations for each. Who is party to the franchise agreement? Here you need to be clear on the other party with whom you are contracting. Is it the franchisor or a master franchisee? Is the franchisor company a trading subsidiary of another company? And whoever it is, you need to know and give it consideration. After all, a long-term franchising relationship involves both parties being around for the long term. You will want to be confident that the franchisor and/or master franchisee will be around too. Grant and scope. This is where the franchisor grants the franchisee a franchise to use the franchise system, including intellectual property such as brand names, trademarks, and the franchisee manual. As well as other considerations, the franchise is usually granted for a specific and limited period of time and within a particular territory. The franchise term. Franchise agreements are normally granted for a specific period of time. Franchise agreements commonly have an initial term as well as renewal periods. It would not be uncommon to be offered, for example, a 5-year agreement with 2 further rights of renewal at 5 years each, thus providing a total potential term of 15 years. However, there are many examples providing less time or more time, and these are often provided for valid reasons, such as to coincide with a property lease. You will want to know about specific renewal rights, including whether renewals are at the franchisee or franchisor's option, what renewal fees are involved, as well as the details of many other relevant aspects. Fees, franchise and otherwise. The franchise agreement is normally the location where the majority of fees are described. These commonly include initial franchise fees, royalties, local and national marketing fees, service fees, renewal fees, and transfer fees, along with how they are calculated. Territories. Some franchise agreements provide rights to exclusive territories, whereas others do not. Where exclusivity is provided, there are many possible variations, which we discuss later in the program. Products and supplies. Franchise agreements, often in conjunction with franchisee manuals, normally contain sections relating to what products or services can be offered and where these are to be purchased from. You will want to know what you can and cannot sell, and also what product will need to be purchased from where and on what terms. Compliance with the franchise agreement and franchise manuals. The franchise agreement and franchise manuals both contain requirements for franchisees to comply with. These are designed to protect the brand and franchise system, including franchisor and franchisees. The franchise agreement will normally clearly state that the franchisee must conduct the business in strict accordance with the franchise manual, and you should be comfortable with the requirements set out in both documents. Reporting and audits. The franchise agreement, in conjunction with the franchise manual, will typically outline a range of franchisee reporting and audit requirements. That may cover areas such as regular activities, financial and non-financial key performance indicators, and local market research. Typically, franchisors also reserve the right to appoint an auditor to make an independent audit of the business or the franchisee's annual financial statements. Intellectual property and confidentiality. Franchise agreements make many points about intellectual property, covering areas such as definition, ownership, use, enforcement procedures, ownership of improvements, and ownership of goodwill. Franchise agreements commonly provide franchisors with the ownership of any improvements to the franchise system, even if devised by the franchisee. Termination and consequences. The agreement will expire at the end of the term unless it is renewed by the franchisee, subject to the rights of renewal being included in the agreement. Once all the terms of years have been used, the agreement expires and is therefore terminated. A franchise agreement can also be terminated by the franchisor should the franchisee default under its terms. You need to understand the franchise agreement to be aware of what potential exists for your franchise to be terminated and put in place appropriate business systems to ensure that these events do not occur. Transfer or sale of the franchise. Franchise agreements typically provide certain restrictions on the sale of the franchise, and these are often centred on ensuring the incoming franchisee is a good fit. One important requirement normally involves the franchisor approving the potential purchaser of an existing franchise. Other common restrictions may involve when a franchisee can sell, how it is marketed, and what, if any, amount may be payable to the franchisor as part of the sale process. Restraint of trade. Franchise agreements normally include provisions that restrict what a franchisee can do during and when they sell or exit the business. Such provisions are designed to protect the value associated with the particular location or unit and the franchise system. Put simply, how would you feel if you purchased an existing business from a franchisee who then set up the same business under a different name across the road? There are also many further common elements covering areas such as franchisee premises, insurance, marketing, training, attending meetings and conferences, franchise advisory councils, field visits, business and computer systems, a nominated manager, confidentiality, death or illness of a franchisee, dispute resolution, controls on warranties and representations to customers or third parties, terms of trade with customers or third parties, required compliance with laws, limited price regulation, maintenance or upgrades, brand adjustments or refreshes, performance expectations, enforcement rights, employment issues, and stated and accepted acknowledgements by the franchisee. Final notes. When reviewing the franchise agreement, remember to take into account that its prime purpose is to protect the integrity of the franchise system and all of the franchisees in it, as well as to protect the franchisor. Some terms may seem harsh, but they are usually included to ensure that the quality of the franchise system is maintained for the benefit of all. Before signing a franchise agreement, remember to seek advice from an experienced franchise lawyer. See the Franchise Association website for a list of member lawyers. More information on legal advice and a franchise lawyer's role is covered in a later module.